OSHA shows up at your facility for a surprise inspection, but the compliance officer isn't alone. They brought a guest. You are now facing an inspector accompanied by an unknown outside advocate who expects full access to your production floor. This is OSHA's updated walkaround rule. As of May 31st, 2024, the federal government officially rewrote the rules governing exactly who is permitted to see inside your business. Before we break down the defense strategy, a quick reminder: this video is strictly for educational purposes and does not constitute legal advice. Always consult your employment counsel for guidance specific to your operations. For decades, federal safety inspections were strictly internal affairs. The compliance officer arrived, walked the floor, and spoke privately with your own employees. The entire assessment was kept securely within the company walls. That expectation of privacy is gone. By throwing the gates open to non-employee third parties, this update creates a massive operational blind spot for facility managers. The standard compliance playbooks you've relied on for years simply do not account for these outside observers. What used to be a straightforward review of machine guarding and hazard communication now carries immediate legal and labor vulnerabilities. An inspection exposes your internal processes to individuals who answer to organizations with entirely different agendas. To understand the mechanics of this threat, we have to look at the exact legal update to 29 CFR 1903.8c. Previously, any representative accompanying the inspector had to be an internal employee of the company. The new text formally expands that authorization, granting employees the right to designate a non-employee third party to walk the floor. The regulation does include a filter. The third party can only enter if their presence is deemed reasonably necessary to conduct an effective inspection. But the authority to waive that filter rests entirely with the individual compliance officer standing in your lobby. In the past, the Department of Labor recognized a very narrow exception for outside experts, limiting entry to credentialed industrial hygienists or specialized safety engineers. That definition has been rewritten from the top down. Now, an inspector can justify entry for union organizers, plaintiffs' attorneys, or community activists. The only requirement is that the inspector feels this person brings relevant knowledge, or even just useful language and communication skills to the inspection. The legal standard for entry has shifted away from objective technical safety expertise. By allowing generalized advocacy to count as a valid qualification, the barrier for facility access has been drastically lowered. For non-union facilities, the practical risks are severe. Because outside representatives can now legally access your property under the protection of a federal inspection, you face the immediate threat of backdoor union organizing occurring during active work hours. Beyond labor relations, there is a secondary threat to your intellectual property. Plaintiffs' attorneys and outside consultants can use the walkaround to conduct pre-litigation discovery, scouting for lawsuits while observing your proprietary workflows and trade secrets. The business community has heavily resisted this update. Trade associations have launched ongoing lawsuits to block the rule, arguing that forcing private companies to admit non-government outsiders is a direct violation of their property rights. With outsiders actively listening, internal misalignment becomes dangerous. If a supervisor explains a lockout-tagout procedure differently than a floor worker, a third-party advocate will document that discrepancy. Consistent safety messaging across the entire internal team is an absolute necessity. An OSHA inspection can now simultaneously serve as a legal fishing expedition or a labor organizing campaign. These regulatory changes shift a routine site visit into a multi-front legal and operational challenge. Neutralizing this advantage requires proactive administrative controls long before an inspector ever arrives. You must form specialized internal inspection response teams and establish impeccable audit-ready record-keeping so outsiders have zero leverage to exploit. The most effective defense is a highly visible internal safety committee. If your own workers are already actively managing safety programs, they become the most logical choice to aid an inspector, which directly undermines the justification for bringing in an outside advocate. Next, you must implement a rigid visitors policy. Require every single person who steps onto your floor to wear specific personal protective equipment, undergo a documented safety briefing, and sign a strict confidentiality agreement. The critical legal requirement here is uniformity. This visitors policy must apply equally to all visitors, vendors, and contractors. If it is standard operating procedure, enforcing it on OSHA's chosen representative cannot be framed as retaliation or obstruction. These proactive administrative controls create a legal box. By setting the terms of engagement early, you restrict third-party behavior and protect your proprietary information before the outsider ever steps foot on the property. On the day of the inspection, the opening conference is your firewall. Vet the third party's credentials immediately and professionally require the compliance officer to articulate the exact good cause they are using to justify the outsider's presence. You also retain the legal right to protect your trade secrets. Under the law, you can explicitly restrict the third-party representative from accessing sensitive proprietary zones or viewing confidential manufacturing processes. Once on the floor, your management team must actively police misconduct. If the third-party representative starts wandering away from the compliance officer, taking unauthorized photos, or attempting to solicit your workers, you have the authority to step in and stop them. Rather than viewing this regulatory shift as a disaster, use it. This rule provides the strongest possible reason to ensure every worker on the floor is trained, compliant, and ready for external review at any moment. The best time to prepare for an OSHA inspection is right now, before the inspector knocks on your door. Subscribe to the HSEstudy YouTube channel for more tactical compliance strategies to protect your facility. Ultimately, control over the facility remains with you, provided you exercise your constitutional and property rights confidently, legally, and without hesitation. You dictate the terms of your own defense.